Today, I wanted to talk about the role of the family dispute resolution practitioner. So some of you may know I'm one of the hosts of a really active group on Facebook for family dispute resolution practitioners and students. And we have a bit of conversation in there, and there's some perceptions that FDR is only for parenting or has limited roles. I thought it'd be really good to have a look at the role and the role expectations of what a family dispute resolution practitioner is and what we should know. Before I go any further, though, I'd like to acknowledge Aboriginal and Torres Strait Islander peoples as the traditional custodians of Australia country and recognise their continued connections to land, waters and culture. We pay our respects to elders past, present and to the emerging leaders. I come to you today from the lands of the Gunai people in Gippsland in Victoria. Thank you. I can see all of you, or some of you at least, are starting to put in your introductions and who you are and where you are. And also, it'd be great to know anything specific that you're hoping to get from today's session. So what I had is a little bit of looking at the context within which we work and at the Family Law Act and the regs and how everything fits together. What is the role of the family dispute resolution practitioner? So the current role was established in the amendments in the Family Law Act 1975 back in 2006 and subsequent development that was required. So it came into effect on the 1st of July 2008. Before that, there were family law mediators. So it's not that the FDRPs appeared out of nowhere. There was some additional training at the beginning. It was just bridging training to get people so that they were available. But there's been a continual process of increasing the rigour, I suppose, of the training since then. We're bound by the Family Law Act, the Family Law Family Dispute Resolution Practitioners Regulations, 2008. And the training requirement is set out in the Graduate Diploma of Family Dispute Resolution, and I'll talk about that a little bit more. And our regulators, the Australian Attorney General's Department Practitioner Registration Unit. So that's our context that we work in. Section 10F of the Family Law Act says that family dispute resolution is a process other than a judicial process in which the family dispute resolution practitioner helps people affected or likely to be affected by separation or divorce to resolve some or all of their disputes with each other, or helps people who may apply for parenting orders under Section 65C to resolve some or all of their disputes with each other relating to the care of children, and in which the practitioner is independent of all parties involved in the process. I suppose a couple of key points from that context, not just people who are already separated. We can have a restorative role as well in helping people to resolve issues so that they don't separate. As for those of you that are FDRPs already, you'll know that we have an obligation to ask people if they are sure that they want to separate, refer them to family counselling services and things like that if they indicate that they're ambivalent about it. So just a reminder that we work in that period of time between people thinking of separating and then up until the point where they don't need any further assistance with their children. It's not just for parenting. People get confused because of the Section 60I. It only applies to parenting, that the role of the family dispute resolution practitioner is only for parenting, but that's not the case at all. So parenting, property, financial issues related to separation and divorce are all part of the scope of our role. And it's not just for mum and dad. So anyone who's able to apply for a parenting order is someone who can approach a family dispute resolution practitioner for services. Grandparents are pretty common. We know that the definition of who a family member is for First Nations people, for Aboriginal and Torres Strait Islander people, has changed. So now it's basically a family member is whoever is a family member for that family, according to cultural and other expectations of that family. But under the basic definition for non-Indigenous people, aunts, uncles, grandparents and other family relatives are mentioned. It's also something I think to consider when child protection services are involved and they've taken on parental responsibility, whether they should be involved as well in a family law context, because at times the distinctions between family law and child protection legislation can cause issues, particularly I think as we're thinking about the best interests of the child and what that actually means in terms of, one, being safe from violence, but two, also having their developmental and other needs recognised. We've got a webinar later in the month where we'll be talking a little bit more about some of those factors with some of our First Nations FDRPs. So it should be an interesting conversation. Won't be just me talking, but feel free, anyone who does want to make a comment about any of this, and I can see you using the chat, which is great. As we saw, clause B of 10F is that in which the practitioner is independent of all parties involved in the process. So that isn't actually defined in the Family Law Act. What does that mean? Generally, what I would suggest is that they're an impartial third party who does not have a personal interest in the outcome of the dispute. And we can look at some of the ethical obligations in the regulations to help guide us about what would have impact our independence or our impartiality. But ultimately, an FDRP must not take sides or discriminate for or against a party. But it's a little bit complicated because we've also got to facilitate communication, and sometimes one party is going to need more assistance than another. We've got to keep the process safe and ensure that the best interest of the child and any duty of disclosure requirements are respected as well. And the other, another aspect to really draw out, because it's an area where independence may be compromised, is in decision making. Family dispute resolution is intended to be a process of self-determination by the parties, and it's an important aspect of the roles. We don't have a determinative role, and so to be independent, we need to be mindful of not taking sides while we're helping parties to come to a decision. But we also have an obligation to ensure that they consider their obligations under family law, and particularly in terms of the best interest of the child and other aspects. So does anyone have any other thoughts about the role of how we maintain our independence? And Kerry, you've asked more about the role of FDR's role in CIP. Is that in the context of independence? Because it can create an interesting dynamic. There's a couple of primary models for child inclusive practice. One, which was quite a lot of people have done the training in by Jennifer McIntosh, who was also involved in developing the DOORS, detection of overall risk screening. And it's the case where the child inclusive practitioner, who may be a family dispute resolution practitioner, meets with the children and the parents, but isn't the FDR who's facilitating the main process. There's another model where the FDR practitioner does go and meet with the children and then facilitates the FDR process as well. So there's a balancing act there. The definition of family dispute resolution doesn't include that, but it's something that we need to maintain our role regardless of that. There's also family group conferencing, and that's a process where the children are actually present and involved in the family meeting that's coming up with a plan for their care and welfare. It's, again, mainly used in a child protection area, but it's a case where the child may actually be present. And for some FDRs, it's, shock horror, no, we'd never do that. But it's pretty commonplace in the child protection area. Yeah, there's various models, but the basic principles still apply. The guidance about what an FDR practitioner is even more limited in the Family Law Act. It says a person who's accredited as an FDR under the accreditation rules, which are the family dispute resolution practitioners regulations. So we need to go to the regulations to actually see anything beyond that. By the way, the regulations are sunsetting. They have no more scope to extend them, as happened last time. So they're under review at the moment. So we'll have some new regs that are going to be in place on or before the 1st of April 2025. So for those that are feeling a little bit change fatigued, there's a little bit more to add on top. So I've just done a little flow chart of how these dependencies go. So the Family Law Act established the role of family dispute resolution practitioner. There's some legislation that actually specifies some of our obligations, such as information to provide to parents and around Section 60I certificates and other things. But there's also some guidance in the regulations which relate to how we become accredited, our practice standards, and what might lead to loss of accreditation. And then our regulator is the Attorney General's Practitioner Registration Unit. So they're responsible for administering the registration according to the regulations. And wonderfully, they also provide us with some guidance and support, which is very good. So just with registration, I'm not going into the detail here, but I think I forgot to update the top part of the slide. So we'll just look at the bottom part. What's required to be an FDR practitioner is education, which is either graduate diploma of family dispute resolution, and to enrol in that, you need to have a law, social work, psychology degree, other dispute resolution qualifications, national accreditation as a mediator, or working in a dispute resolution environment in a role where you've got autonomy and some decision-making capacity. So there's basically what that says is that there's some prerequisites to be able to become a family dispute resolution practitioner as far as education or experience. If people don't want to do the full qualification, there are core units. So there's 6 core units out of a 10-unit qualification. And if they've got one of those degrees, law, social work, or psychology, they're able to register unconditionally as a FDR practitioner, or if they have the core units and national accreditation as a mediator. So NMAS accreditation is going to be changing to AMBRAS accreditation from the 1st of July. It'll just move across as well. And then things will be tidied up in the next lot of regs that come out. You must be of good character. So it's a role where we have quite a lot of power in a situation when people are quite vulnerable. And so there's a requirement that we have a police check and we don't have any convictions for child abuse or sexual abuse, violence, or other offences related to poor character, so fraud and things like that. We need to meet the working with children requirements in our state or territory. There's certain declarations and ongoing obligations. So as an FDRP, we need to notify the department within 7 days if any of that changes. So it's really important to recognise that there's a lot more scrutiny that's required for someone to be an FDRP than someone who just says they're a mediator or says they do family mediation. Certainly, I do everything I can to educate the community to make sure that they're only working with qualified family dispute resolution practitioners. And then there's an online application process. There's a register of FDRPs. It is optional. It's not mandatory like the register for nationally accredited mediators. And we've got ongoing professional development obligations. And the obligations are around maintaining currencies as an FDRP. So it's not just spotto, collect 24 bits of PD. It really needs to be making sure that you're maintaining your currency. At the moment, because of the changes to the Family Law Act, there's quite a lot that we need to do and take responsibility for doing. So there are some higher education colleges that provide training that's regarded as equivalent to the 6 core units. But basically, the body of knowledge that an FDR practitioner needs to have is a understanding of the family law environment, the family law, the family court, so the legislation around that, family violence legislation in the states or territories that we work within, and the Privacy Act legislation. So we need to have a pretty good understanding of how all of that fits together, as well as our specific obligations within that legislation, manage and respond to domestic and family violence, and then facilitate family dispute resolution process ethically, and really, again, looking at the safety of vulnerable parties. So when we look at the regs, we must not provide family dispute resolution if someone won't be able to freely make decisions in the process. And it's usually family violence that might be the factor, but it can be mental health vulnerabilities, alcohol and other drugs, or a whole range of vulnerabilities that might mean a person isn't really able to self-determine in a mediated process at this time. So having an understanding of how we can manage and mitigate some of the risks around there, but ultimately the rules say we must not facilitate if we can't. And the final unit is around working with a child-focused approach. So very much it isn't about a couple of parents coming to negotiate how to do the property settlement and forgetting about the fact that there's children that are going to be impacted by the decisions. That's one of the reasons I really discourage non-FDRs. They're going to do a process where they are ignoring the children because, I don't do child related stuff. You can't divide up a asset pool from a family without impacting the children. So having a child-focused approach in all of the work that we do is critical. Now, these next slides are horribly text heavy. I will make the slides available, so don't worry about having to take notes or anything like that. And I'd really like, if anyone's got any comments as we go, either in the chat or feel free to come in and talk about it. What I'm looking at is just basically the listing of things that we're expected to know in this qualification. So we need to be able to determine and respond to family law requirements. Our specific requirements are around suitability, issuing a Section 60I certificates appropriately, and remember, it's only family dispute resolution practitioners who are able to issue these certificates, and we've got some obligations around what we need to determine, what information we need to provide to parties. And we've done some previous trainings on the specifics of all of that, but if anyone's got any questions, feel free. I'm half monitoring the chat, so I might notice if you have put a question in there. If not, feel free to interrupt my monologue. I'd be very happy for you to do that. We need to facilitate legally and ethically. So the regulations provide some of the ethical obligations. If you've got other professional roles, such as being a lawyer, you've got professional obligations there that you shouldn't be breaching as well in the process. So you need to balance those. We've got to provide legal information. Like we must make sure that our clients are informed, but the regulations are ambiguous about providing legal advice if you are qualified as a lawyer. But if you are doing that, you need to do it in a way that wouldn't damage your impartiality and wouldn't breach your ethical obligations as a lawyer, which normally would put some severe limits on you providing advice to people who have conflicting interests, which is pretty much any client in a mediation or FDR process. Thanks, Marilyn, for dropping that in, the link to Jenna McIntosh's program. It is very well founded. We have to collaborate with others in the family law system, and this is possibly an area for people to reflect on how well we are doing that, because we have a very specific and defined role, whereas clients' needs at a time when they're separating and divorcing or trying to manage care of their children is post-separation is much wider. We need to develop an understanding of what other services are available, what networks refer clients. Referrals to another professional by a family dispute resolution are inadmissible, and that's really important. We need to understand that just referring a client without telling the other practitioner that it's inadmissible may mean that the clients don't have that protection and aren't able to freely, for example, get the mental health support that they need. So looking at the way that we can refer, using a referral form that explains the inadmissibility can make a big difference to how well people make use of services that provide the support that they need, so they're in a better place to care for their children and participate in mediation or whatever other services they need. We need to work with lawyers and other advisors, so know a range of services providers that we can send clients to, that depending on their means and their needs. we certainly can run lawyer inclusive processes. Some FDRPs, all of their mediations have lawyers present, others only as needed, and some don't run a process at all with lawyers included. Personally, for me, it's when needed. Maybe we could, for the practitioners here, if anyone's got a thought of how often you have lawyers present at the time in your mediations, that'd be interesting to know. Other support people and others within the service or within the process. So that collaboration, sometimes we hide behind the confidentiality of the process and forget that clients own their information and they can give us permission to talk. So often, particularly if there's a family violence order in place, I might ask permission of the client to speak to their lawyer that's working with them on that case, because we need to get a feel for what's going to be possible within the context of, depending on the type of order, and how it's going to interrelate with the protection that's needed for the protected family members. So that's one example. If you're doing any court-ordered FDR, so with the merger of the family courts and the new case management approach, there's a lot more family dispute resolution that's being ordered out to private practitioners and even to some of the family relationship services and FRCs. Again, we're interacting with the lawyers, trying to, my experience, sometimes trying to get them to provide the information they're required to provide to us in a timely manner. I don't know if others have had the experience of, despite requests, getting the stuff the night before the mediation. But yeah, making sure that we've got those information flows happening in an effective way. And one of the other competencies, and these are in that first unit, the unit about operating within a family law environment, is contributing to workplace improvement. So it's really looking at, as an FDRP, we have a positive obligation to maintain our currency. It's not something we can say, oh, my workplace didn't tell me. You, as a registered practitioner, are responsible for maintaining the currency of your family law and related knowledge. When the family violence legislation in your state or territory changes, it's important that you check what are the changes, what are the impacts, look for professional development opportunities to maybe engage with the magistrates court or other legal practitioners that are working in that court to get an understanding of how those changes may impact clients that are also engaging with the family law system. Looking for opportunities to improve the way we meet family law responsibilities. At the moment, we should all be very busily going through all of our documentation to make sure that our definition of the best interest of the child is relevant and current, making sure that our information about parental responsibility is current, making sure that we've updated our information that we must provide to clients and all of that. If you're a student and you're saying, oh my God, don't worry, we take you step by step through everything. So clearly articulated what we need to do. So it's not just a random bunch of information, but we need to stay on top of it. We need to continue to be looking at ways we can improve the information. So if your client group is different, then maybe there's information in community languages or other ways that you can help to improve. And Marilyn, was there anything, I've seen you've made a few chats, is there anything there that's relevant to bring in at the moment?
All I was just going to say is, just with the property settlement, when we were talking about the legally, quite often the legally assisted mediations work well when the parties really do recognise the need to settle, but they just can't. And the lawyers play a great role in getting the negotiation, rather than have a mediation where you're unable to help the parties, because we own the process, we don't own the outcome, so we can't push it through. We've got to be careful there. But when the lawyers are there, when the room is managed correctly, they can be a great asset, because you can have breaks and discuss together the next steps. And if the lawyers know and understand that you want to resolve the mediation there and then, and everyone's on the same page, it can really, because a lot of people, there's just no going to court. By the time you divide everything, you pay for your lawyer. If you go to court, you'll lose everything. So
absolutely. And look, often people don't actually want to listen to their lawyer as well. I find that I'll often suggest, when we get to a deadlock and I know the party, like I find it very unlikely that what they're saying is what their lawyer's telling them. So bringing everyone together.
That's a very tricky one. Yeah. I had a situation where I was doing a property settlement private with the parties, and I had spoken to them before they went in. And there's a bit of school of thought out there. I can't remember the guy who teaches it, but he says never go into a mediation unless you know that the parties are 20% either way. I reckon it's 10% actually either way. But then again, everyone's different as well. And what happened was they told me that they wanted to do a 50-50 split, or it was a 55-45 split, but the mother hadn't told her solicitor. So I'm like, but she got on the phone to the husband before the mediation and told him that she wanted to do 50-50. Everyone's just so busy and lawyers just jump in and they're running on their feet. And I knew what they wanted, and we're getting partway through it and it's just not working out. And we'd already had a private session. And I'm like, this is starting to fall apart, because the father started to get very angry because he thought she'd gone back on her word, which I didn't know. They'd decided this before the mediation. I just knew something was going weird and I didn't know. And her lawyer was really fighting hard for her. And I just said, look, you know what? I think we need to have a private session. It's okay. We can do 2 private sessions. I'm going to have a talk to you individually. I never said too much, but I went into the private session and I just said to the father, what's going on? And I had his lawyer in there too. She was young. And I said, why are you getting upset? And he said, she rang me this morning and said that we we're going to do 50-50 split. I'm sure that's what he said. Very close anyway. And I said, okay. And now doesn't seem to be happening. And I said, okay, we just talked for a bit. And I said, just relax. Let me just go over to the other side and just have a talk. And then we'll come back in. I can't make people do things. And I can't even say I believe that you even had a talk this morning. So I've got to be very careful. So I went over to her and she didn't have a solicitor in the private session with me. And I said, how are you going? And she said, oh, I've got a big problem. And I said, what's the problem? And she said, oh, I want to do 50-50. I told him this morning that I was going to do that, but my lawyer, I forgot to tell him. And I just went, oh. So now how do we save face and keep the thing on track? So I said, maybe... So creative problem solving, we're able to do that. This is not advice. There's a few options here. I said, perhaps you could just tell your solicitor that this is what you really want to do and you've thought about it and you really want to do it now. And because, and that's something you could perhaps tell him, or you just keep going with what he's doing, which may not be a good idea. We took the best alternative to a solution and the worst alternative. We went through that. And I said, and you have to talk to your solicitor. I can't tell him because it's a tricky role there with the relationship between the solicitor and the mediator, because we don't want to tell him how to do his job. And if he doesn't know that this has been negotiated before you come in, he's going to be, it's saving face and everything. So I said, maybe you just tell him that's what you want to do and you've decided it now. If that is what you want to do, that's one way to get around it. So what happened was everyone then just had a 5-minute break and everyone came back in. And she must have told the solicitor, because the solicitor started to go down that path and it all started to work. But if I hadn't have sensed this is going diabolically wrong and I don't know why, and then had a break to clarify, it could have fallen apart and it could have ended up in court. So it's just one example of how tricky it can be.
Absolutely. Yeah, no, for sure. And Tracy.
Okay. Just a question on the mediation you were just describing. Was that a collaborative one or legally assisted?
It was a legally assisted mediation.
Okay.
It was when the Family Law Act first changed and the 2 courts had amalgamated. Now, it was really tricky because the solicitor for the mother was South American and English was a second language. Her lawyer was South American, so they would speak to each other in their native tongue. So it required quite a bit of cultural awareness, but it also required real sensitivity and understanding the dynamic and when it changed. And I've been working with them for a little while, but the mother's solicitor he was old school. Let's just say that. He was old school. So what do they call him? Paralegal. Paralegal was doing a lot of the IT and getting things set up for him. And the amendments had just changed with the overarching purpose of what Anne-Marie Rice was telling us all, to solve matters as quickly and as cost effectively as possible, that mantra of hers that we all know. And he already had a court date organised, and I think he may have thought that, what's this mediation all about? He was pleasantly surprised at the end. He was actually thanking me. So you see, everyone's learning, aren't they, about this whole new way of doing things. But yeah, Tracy, is there anything else you wanted to know? It was just lawyers, and the two lawyers and myself.
Correct me if I'm wrong. It was sounding like that the lawyers were actually speaking in the mediation.
No, now this is how I do this one. This is a little bit tricky too. The lawyers were speaking in the mediation. The lawyers knew their role. I'm very strict with what their role is in my agreement to mediate. And they understood that I was the chairperson of the mediation, and that if the mother needed to speak to her lawyer, she was able to, for clarification, because English wasn't her first language. Now, I allowed that, and it worked well, and I'm not sure that it would have worked as smoothly if I hadn't have allowed that. And look, I know there's a couple of schools of thought about lawyers in mediation and support people. Obviously, they don't speak at all. Their role's quite clear, and that's written out. But I'm not adverse to having a well-intentioned, holistic, collaborative lawyer speak within a mediation when they're looking at the best interests of the children. And you'll see very early on whether they're adversarial or whether they are collaborative. Now, if a lawyer is adversarial and they start, I've had one lawyer actually, I've spoken to the client and she said, don't answer that and turn the camera off and the sound off. And I got quite angry at that. I said, put your camera back on. This is not about litigation. You're not here to, we're not doing a boxing match here. This is about mediation. It's about coming together to look for a solution for the whole of the family. So you agree when you signed the agreement to mediate that you would follow these instructions. So can you please do that? And she didn't turn the camera off again. But I've had all sorts. Anyway, yeah. I won't dominate this.
And that's great. It highlights the diversity of practice. So the lawyer inclusive FDR can range from the way sometimes legal aid does, where everyone's in separate rooms, there's no direct communication with the parties, and the lawyers are talking with their clients, to ones where the lawyers can be present but they're not to speak in joint session, to somewhere in between where they can be involved in the conversation. I'll often do it that way as well, because there's some benefits from that. And for me, I guess from that collaborative mindset, and I've trained as a collaborative coach as well. For anyone who's not aware, collaborative family law is a process where all of the advice is given jointly in joint sessions with the clients and both lawyers present, and they contract not to go to court. So we can run FDR in a similar way, so that, and it can be very helpful where there appears, based on what the clients are telling us, that there's conflicting legal advice. Marilyn gave us a great example, whereas a miscommunication is causing problems in the mediation, often a miscommunication around the legal advice can really be a big blocker for progress for people. Yeah, so excellent. Thank you. That was great little insights there. And Tracy, you also in the chat dropped in around the different family court legislation in WA. Absolutely. So Family Court of Western Australia, it is aligned with the Family Law Act, and now most of the major provisions, they're finally aligned so that the property or rather superannuation splits can be done in WA. Before that, it wasn't. So people could have a good chance of shopping which court they wanted to be in when the FIFO worker's partner went home. But it's not the same. The central practice direction and some of those, my understanding from what people in WA say, the culture of the court hasn't changed as much as it has under the Federal Circuit and Family Court, with that very strong focus on trying to minimise the cost and time. If someone's got a different perspective, I'm more than happy to to hear it. But yeah, that's what.
Yeah, Joe, in last week we had Family Law Pathway Conference, and the Chief Judge gave a presentation about the new changes, and it was interesting. I screenshotted the slide that she had up, but I'm actually want to dive into it a bit more. And she had on there that no mirror amendments yet to the Family Court Act for children whose parents were never married. So I just found that really interesting that she's highlighting that, and that's something obviously still
a
in
distinction
progress.
there.
Yeah, so it's
Yes, it
always
could be something to delve further into. Thanks for highlighting that.
it's a watch this space thing.
Yeah,
Her first bullet point was amendments to the Family Law Act, children whose parents were married, and the second bullet point is no mirror amendments yet, highlighted yet, to the Family Court Act 1997 WA, children whose parents were never married. So it'd be interesting to hear or understand what's in the pipeline or what they're looking at.
Yeah, that's very interesting. I'll make a note of that.
Know that, Joanne.
Yeah.
I thought Western Australia was in line with us in terms of the paramount principles being changed to 6. And yeah, so I didn't know there was a distinction between parenting with de facto marriage. I know with the property in COVID, I did quite a few, and I had to really get up to speed in terms of the de facto laws and the superannuation, and also the Section 60I certificates were different. It's a little bit problematic, really, because we really do need them to be in line with us, with everybody living everywhere and travelling everywhere.
Yeah, it's interesting. So they have updated the super. It did take extra long for the bill to go to an act with COVID, but that's interesting, Tracy. We'll need to, and there it goes. It triggers our requirement as FDRPs. There's something there maybe where there's something we need to understand and delve into further. Yeah.
Joanne, I've just sent you an email with the screenshot of that.
Beautiful.
What it is. Just, see if you can decipher it better than I, then wonderful.
That's good. I'll look into it. I had someone the other day that asked about the new amendments for property. They're not actually through yet. There's a third Family Law Act amendment bill that's will make its way through at some point, probably, and then we'll have another upgrade because there's some fairly significant changes proposed with property for property settlements. But so we'll look into that and we'll come back with what we can find. It's pretty shocking to think that children of de facto families would be treated differently to children of a married couple, but that'll be really interesting to find. Oh, thank you. You dropped it in there. Yeah. So we've probably only got enough time to have a look at our obligations around family violence. So that second unit of competence. We've got to analyse the impact of domestic and family violence on clients. And what's required is that we need to research and maintain a current knowledge of the dynamics of family violence. So in some of the states, New South Wales, they've got the making coercive control a criminal offence so that it's not just the civil intervention order regime, but people could actually be charged with criminal offences for that sort of behaviour. We have to be able to assess and respond to safety concerns, recognise and respond to the impact of violent, controlling, intimidating and belittling behaviour. As FDRPs, we're not just looking at the physical abuse, but we're looking at the effects of emotional and psychological abuse on people and how that can impact both their engagement in the FDR process and the wider impacts on them as parents and as people. And we need to recognise and respond to the impacts of the working with family and domestic violence on ourselves and also on our colleagues. Recognising, particularly if you're working within a service, if one of your colleagues is really starting to feel the strain and they're not getting the appropriate support. One of the earlier signs is empathy fatigue, where people's empathy drops down and they start talking badly about clients and things like that. Can be a red flag for someone who's struggling to manage their own being in working in this work. sometimes because we're not out in the field, we're not like paramedics picking people up off roads. Sometimes people think it doesn't have the effect, but yeah, it's certainly, there is a real risk of vicarious trauma and to our own mental health from the sorts of things that people tell us have happened in their lives. Working within the legal context, again, in the family violence context, the family violence, child protection, legal frameworks. If you don't understand what goes on in child protection, that might be an area for looking for opportunities for professional development to understand more, or connecting through networks or whatever. Child contact services, if you haven't got a good understanding connection of what's available there's another opportunity, so that kids can still have contact with a parent that they love and they want to spend time with, but we're not sure that they're safe. Information sharing around agencies, things like we have to make mandatory reports. We need to let people know about behaviour change programs and other support programs that might be available. And we have an obligation to share information about the law. So if people are disclosing family violence and we just fill out our form and we don't talk about it as being illegal or what the issues are or name it, we're running the risk of perhaps colluding with someone who's using abusive tactics, and we don't want to do that. So we definitely need to be equipped and able to talk about the behaviour that's being described, particularly with the user of violence, because often they, because of their own life experiences or family culture, may find that their behaviour is perfectly normal and acceptable. There's all sorts of issues there that we need to be able to deal with. And part of our role as FDRPs, wow, that's cool. Sorry, who's that? Who are you, iPhone user? You mentioned that you're travelling New South Wales at the moment, presenting deep dive workshops and forums on the new coercive control laws. So very interesting indeed. So yeah, it'd be great if you could share some more information about what you're doing there. Oh, excellent, Sharon. You might like to, let's talk. And that's the thing, like we're very fortunate within our sector. We have such an amazing body of people that are doing awesome work, and finding out who's doing what, connecting, learning about these different nuances. There's the other thing that we're meant to provide clients with information about is the programs for them if they can't manage after orders or they can't self-manage care. So whether it's parenting coordinators or courses, making sure that we can help people to access the support. And what the qualification says around working with people who use family and domestic violence is engage with users of violence with respect, honesty and concern for the safety of others. Really using those accountability frameworks and talking about what isn't acceptable and trying to engage them in programs that can assist them, and the impact of violence on partners, family members and children, and why perhaps what they're asking for in the context of the family violence orders and other things that have been going on and what they've disclosed, why what they want in terms of parenting arrangements may not fit within the framework of what's in the best interests of children. Yeah, lots of opportunities. So that's all we've got time for today. I don't know if this was helpful at all, but I will make the presentation with all of the various skills and competencies and other things that we're meant to have available. So it might be helpful if you're thinking about what are my PD options, where am I wanting to focus and learn more about? It might just think, oh, that's an interesting area. So hopefully, any final thoughts or comments? And Rowanna's put a plug in. If anyone does want to present a webinar, we're always very open to member presentations, and it's a very helpful way to share your knowledge. And also you get bonus CPD points, 3 for the price of 1.
And a certificate.
And a certificate too. Woohoo. That Rowanna made. Thank you. Any final thoughts?